Check out carmarshal.com. The link is in the description. They help support us.
This video shows 3 Virginia police officers repeatedly using stun guns in 2013 on an unarmed black man who died shortly afterwards. The video caught on police cruiser and hospital surveillance cameras shows Linwood Lambert Jr., 46, being taken into custody by 3 South Boston police officers after he was arrested at a motel for a noise complaint.
Get on your stomach!
You can see from this footage that he's repeatedly shocked at the doors of a hospital when he tried to get away.
Roll around. Roll around. Roll around. No, ma'am. On your stomach. On your stomach. On your stomach. Get on your stomach. Okay, just stop. I will. Just stop. I will. Get on your stomach. Roll on your stomach. I'm gonna go there.
He can then be seen slumping, almost unconscious, in the back of a police cruiser. The officers then took him to jail before returning him to the hospital, where he was pronounced dead. Lambert's family filed a $25 million wrongful death lawsuit in US District Court in April against the officers. The videos have emerged as the US is debating police tactics after the deaths of unarmed black men at the hands of officers in Missouri, New York and elsewhere since 2014.
Federal court concludes that taser use can constitute excessive force. Staff writer, T.C. Kelly. When a police officer injures someone by using inappropriate force, the injury victim may be entitled to sue for battery under state law. Those lawsuits can be difficult to win, in part because states often create standards of immunity from suit for public employees that are impossible to overcome. Injury victims typically turn to federal courts when basing a claim on a law enforcement officer's use of excessive force. A federal civil rights statute, 42 U.S.C. 1983, authorizes lawsuits against individuals who, while acting under color of law, violate the federal constitutional rights of another person. A police officer who is on duty and identifying himself or herself as a police officer, by, for example, wearing a badge or making an arrest, is acting under color of law. Police officers may be immune from suit under 1983, but only if it was unclear at the time they acted that their conduct violated the injury victim's civil rights. The use of excessive force to detain a suspect violates the Fourth Amendment protection against unreasonable seizures. The question that frequently arises in excessive force lawsuits is how much force an officer can use before a court will conclude that the force was excessive. That question was recently answered by the Court of Appeals for the Fourth Circuit in Estate of Armstrong v. Village of Pinehurst, a case that involved an officer's use of a taser. The Armstrong case also explored the extent to which public officials are immune from suit for civil rights violations. Facts of the case. Ronald Armstrong suffered from paranoid schizophrenia and bipolar disorder. Based on his behavior before leaving a hospital emergency room against his doctor's advice, a doctor determined that Armstrong posed a danger to himself. Following North Carolina law, the doctor issued involuntary commitment papers to compel Armstrong's return to the hospital. The doctor did not find Armstrong to be dangerous to other people. The police quickly located Armstrong at an intersection near the hospital. They engaged him in conversation as they awaited finalization of the commitment papers. Armstrong was calm and cooperative, although he engaged in bizarre but non-threatening behavior, including eating dandelions and putting out cigarettes on his tongue. Once the police were notified that the commitment papers were ready, they surrounded Armstrong. He responded by wrapping himself around a stop sign pole. 3 police officers spent 30 seconds trying to pry him loose. One of the officers then told Armstrong that he would be shot with a taser if he did not surrender. Armstrong refused, and the officer shot him with the taser 5 times over a 2-minute period. The taser was set to drive stun mode which, according to the manufacturer, causes extreme pain but not paralysis. Tossing Armstrong did not make him more cooperative. The manufacturer of the Taser device warns that tossing a mentally ill individual is more likely to exacerbate the problem than to coerce compliance with the officer's instructions. After the tossing ceased, the 3 police officers, with the assistance of 2 hospital security guards, were able to pull Armstrong away from the pole. They stood on his back, handcuffed him, and shackled his legs. The officers left Armstrong face down on the grass as they collected themselves. Eventually someone noticed that Armstrong had stopped moving. The officers rolled Armstrong onto his back and discovered that he was no longer breathing. Paramedics were unable to revive him and he was pronounced dead on arrival at the hospital. Excessive force. Whether the use of force violates the Fourth Amendment depends upon whether the level of force used was objectively reasonable. That question requires a court to consider the threat posed by the individual, the severity of any crime the individual committed, and the degree to which he or she is resisting arrest. Surprisingly, the district court found it doubtful that the police committed a constitutional violation. Tossing an unarmed, nonviolent individual who has threatened neither the police nor the public seems self-evidently excessive. Doing so 5 times over the course of 2 minutes is tantamount to torture. The Court of Appeals disagreed with the district court. The Court of Appeals noted that Armstrong had committed no crime. His mental illness had recently been assessed by a professional and the assessment gave the police no reason to believe that Armstrong was dangerous to anyone but himself. Armstrong was not armed. He made no threats. Other than refusing to be taken into custody, his behavior was calm and restrained. None of those facts suggested that the infliction of extreme pain was a reasonable response to Armstrong's actions. The Court of Appeals also observed that the commitment order was issued to prevent Armstrong from harming himself. Doing harm to Armstrong in order to take him into custody contravened the very purpose of the commitment order. Finally, while Armstrong resisted being taken into custody, the fear that Armstrong would flee justified the use of only the amount of force required to prevent him from doing so. Given that Armstrong was surrounded by 3 police officers and 2 security guards, it seems unlikely that any force at all was required, at least until other reasonable options, such as having a mental health counselor or a relative talk to Armstrong, were attempted. Concluding that the deployment of a taser is a serious use of force, the Court of Appeals had no difficulty concluding that its use was disproportionate to the need for force. Tasers are designed to inflict excruciating pain, yet the officers spent only 30 seconds trying to persuade Armstrong to let go of the pole before shooting him repeatedly with the taser. As the court noted, immediately tossing a non-criminal, mentally ill individual, who seconds before had been conversational, was not a proportional response to Armstrong's behavior. Qualified immunity. Government officials may only be sued for a federal civil rights violation if the constitutional right has been clearly established in the context of the official's actions. A civil rights violation is clearly established when all reasonable officials should understand that the law prohibits the action they are taking. When a right has not been clearly established, the qualified immunity doctrine shields officers from liability for their misconduct. The Court of Appeals decided that Armstrong's right to be free from tossing while nonviolently resisting arrest had not been clearly established at the time Armstrong's tossing occurred. The court therefore granted immunity from suit to the officers who tossed Armstrong. As a result of the court's decision, however, police officers are now on notice that using a taser on a suspect who poses no immediate risk to the safety of the public or the officer constitutes a civil rights violation for which they can be sued.
County, this is Charlotte County Cop Watch, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County Cop Watch with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me, and I'm sick of it. So I'm trying to wake people up. But my wife would love it if some, if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave a, let's say, actually, yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But, do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt-free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.